What is the Universal Disclosure Protocol for mediations? That is our series for today. Part of the series, Communication Skills with Daniel Rainey. Welcome to the Lawyers and Mediators International Show and Podcast by InstantMediations.com, where we discuss law and conflict resolution topics to educate both professionals and everyday people. Catch regular episodes on YouTube, the Instant Mediations app, and anywhere you get your podcasts. Just remember, nothing in these episodes constitutes legal advice, so be sure to talk to a lawyer, as cases are fact dependent. Hi, everyone. This is attorney Mac Pierre-Louis. I'm a lawyer, mediator, and arbitrator working throughout Florida and Texas.
And I am Natalia Łowska-Czajka, advocate, mediator, and arbitrator from Warsaw, Poland.
And I'm Daniel Rainey. I'm with Holistic Solutions in the U.S.
Hi, everybody, and welcome back, Dan. And thanks so much for my partner in crime, Natalia. So, guys, we're talking today about the Universal Disclosure Protocol for Mediations, also known as UDPM. And gonna have Daniel introduce the topic by explaining what it is, why it's important, and why we're having this conversation about it today. Because this is something that we as mediators have been chatting about ourselves, but we wanted to kind of let the public know a little bit about why this is important. Uh, Basically, why is it important to start having standards, especially standards globally for mediations, in addition to some of the more recent standards that have been coming out, like the Singapore Convention. And so, Dan, go ahead and start by explaining, but I'm going to be screen sharing and showing the website, Universal Disclosure Protocol Mediation.com, but also shortened as udpm.org. And so, if you're listening to this on audio, be sure to go to the YouTube channel, Lawyers and Mediators, and check out the video version of this so you can see what we're showing. You can check all that out, of course, on lawyersandmediators.org as well. Okay, let me start the screen sharing. And Daniel, the floor is yours.
Thank you. Well, UDPM. This comes from work that my partner Ana Gonsalves and I have been doing over about the last 2 years. And it was triggered by the Singapore Convention. We first introduced the idea at the rollout of the Singapore Convention back in, I think it was August of 2019. Now, the Singapore Convention is an attempt by UNCITRAL, an attempt to set some framework around international commercial mediation that will take mediation more into the mainstream. Traditionally, internationally, mediation has been less favored than arbitration, largely because of the perception that there's a difficulty in enforcement, but also because there is a lack of standardization of mediation process. Um, I think that trying to standardize mediation processes across borders is a losing proposition. There are, according to the Schoenville's book back in 2012, 2013, they identified 50 different types of mediation, 50 different approaches to mediation that are active around the world. And everyone who does those thinks their version is right, and they are correct. Their version is right for the work that they're doing. So trying to normalize and standardize the mediation process, I think, is a losing game. What we were thinking about and what we tried to put forward with the Universal Disclosure Protocol is, okay, if we can't standardize the practice, is there something we can do to encourage self-determination among the parties? Because self-determination is about as close as you can get to a universal in mediation ethics. It's not completely universal, but it's pretty close. And many people think about self-determination as that thing that happens at the end of mediation, that you get to the end, and as a party, you have the power to either accept or reject a resolution, and the power to either continue or to not continue mediation. Our thought is that self-determination starts at the beginning of the process, when you agree to go into mediation with a particular mediator and operate under that mediator's approach. And so we think self-determination starts there. the very shorthand version of this is the way we sort of came up with the things that we think ought to be in a Universal Declaration Protocol is we went to every continent except Antarctica and put together working groups of professional mediators and asked them the simple questions. Two questions. One, is a universal disclosure protocol for mediation worth the effort? And second, if it is, what should it include? We got a couple of unanimous things back. The unanimous feedback we got was, yes, this is a good idea. You should pursue this. And we also got a remarkable unanimity in what they thought probably should be included in the protocol itself. And there are 6 items. I'll just run through them very quickly. The first is you should tell your parties about any conflict of interest, of course. And that takes many forms, but it's one of the very first things. You should talk to your parties about confidentiality, how you will guard their information, and how you will maintain the confidentiality of the process, because there are many different ways to do that. You should tell them about your general process, and you should not use the language of mediation, because most parties are not going to understand the difference between a directive mediator, a facilitated mediator, etc. And so in general language, talk about the way that you're going to approach the case. Talk about the role of mediators and the role of the parties. What are you there to do? As a mediator, do you give advice? Do you not give advice? Do you help draft or do you not help draft? So, talk about what the roles are. And in this world where we're crossing borders all the time, talk about your technology. What are you using? Why are you using it? And how does it work? And finally, the impact of venue. Depending on where you are, either as parties or as the third party, there may be local laws and regulations that affect the way you'll do your mediation. You should disclose that and talk about that in the very beginning. So if these are the things that, at first blush, from the parties that we worked with around the world, they said these are the things, if you talk about these things with your parties in a dialogue, not just to throw it at them, but to have a conversation with them and let them understand what the mediation process is going to look like. When they say, yes, I will join you in that mediation, they are exercising their first effort at self-determination, and you're much more likely to be able to work with those parties effectively. And what it also does, and what we intended, was it doesn't directly address culture and nationality, but it takes into consideration culture and nationality in a way that allows for all of the variations that are out there, but it also allows for a conversation about those so that there are no surprises as you go into the mediation with the mediator. You know what you're getting into and you've agreed to it. If you tie that back to the Singapore Convention, the Article 5 and the convention talks about enforceability. And what it says basically is you can set aside international settlement agreements in mediation if there's a gross violation of mediator or mediator process, mediation or mediator process, excuse me. And that's a good idea, but which standards do you use? And what we're trying to say is that if you use the protocol for disclosure and the parties understand what they're getting into when they say yes, and you do what you said you were going to do, then you are upholding the standards that you agreed to with the parties, and that makes it much more enforceable and much more understandable. So that's what the protocol is and how we came about it. The website that is displayed on this particular podcast has a place for endorsement and gives you a lot of information about the background that I can't talk to in a 20-minute podcast. So I encourage you to have a look at it, and if you think it makes good sense, there's a place for you to endorse, and actually a little seal that you can use, a seal of approval that you can put on your website that says that you do in fact endorse and that you understand the importance of self-determination as it applies to the Universal Protocol. So that's the overview. Mac, you got any questions or comments?
Yeah, no, I'll let lady take the floor first. Natalia?
Thank you so much. So, first of all, for our viewers and listeners who might not be that advanced in that, to better understand this, the intersection between the Singapore Convention, which was designed to actually ensure enforceability, and you started saying that the Singapore Convention in its Article 5 actually sets also the grounds to set aside possible mediated settlement agreement. However, the main purpose of the Singapore Convention is to ensure that these mediated agreements are enforceable. And you also mentioned that it happens within the commercial field mostly.
Right.
The Singapore Convention is still opened to be ratified by the countries. As far as I remember, the latest number I've heard of was like almost 50 countries that's already ratified it. I think so. It is going quite well. But correct me if I'm wrong. And please tell us how you see that this protocol can really strengthen and actually also verify, meaning made it more credible, made the Singapore Convention, and whether you think that this universal disclosure protocol could also work for private mediations. What's your view on that?
Well, you ask a bunch of questions.
Ah, me.
In terms of numbers, I haven't looked recently, but I know that there are quite a number of countries that have endorsed it. I think that 50 or more. The number who have actually ratified it is a good bit less than that, but that's rising all the time. So you just have to check the website at Untitled to see what the numbers are now. I'm not sure. Um, it's if you look at the New York Convention on Arbitration, there are some internationally accepted standards for arbitral processes. And if you violate those, everybody knows that you violated them because they're pretty much standard. And certainly since I think the mid 1950s when the New York Convention was enacted, those practices have become established in practice, if not in law. Mediation doesn't have the same background. Mediation, especially international commercial mediation, has not been over the years as much of a presence as international arbitration. In fact, I have a colleague in Cairo who's a mediator, arbitrator, and lawyer. And Mohammed has in the past mediated settlements among his clients, which were then given to an arbitrator and issued as an arbitral decision because they were more comfortable with the enforceability if it was an arbitral decision as opposed to a mediated settlement. That perception that there is a problem with enforcement and the perception that you don't know what you're getting into, those two things together have made people more reluctant in an international commercial venue to use mediation than they use arbitration. I think what the Singapore Convention is trying to do is regularize the practice of mediation, or at least the relationships in mediation, to a point that people can be more comfortable with them. How the protocol fits in with that is, as I said before, you have internationally now there are many ways that mediation occurs. You can have mediators who are completely hands off and facilitative, who will not give you any advice at all, and you can have some mediators in some cultures who are expected to give you advice and make suggestions about resolution. So, because there are so many different styles, and because we're crossing so many borders with mediation, it's very easy to conceive of a misunderstanding about the process on the front end by the parties who are coming to mediation. The way the protocol fits in with the Singapore Convention and with any other private mediation, it doesn't matter what kind of mediation it is it supports the notion of self-determination. You get to, as a party, choose whether or not you engage in that process. And that's a meaningless choice if you don't understand what you're saying yes to. But if you understand what's going to happen and you say yes, then that's a meaningful choice. And that's a choice with self-determination. And that should we think, do two things. One is it should make people more comfortable with the idea of mediation. And it also ought to mean that if you have a complaint about a mediator's performance, you have some baseline against which you can make that complaint. If I say I'm going to be a completely neutral mediator, I'm not going to make any recommendations, and then I try to push you toward a decision, then I'm violating the thing that we agreed to. And there's a reason for me to be able to say that. If I don't have this conversation in the beginning and my expectations are there and they get violated, then it's much more difficult to say there's been something untoward happening because we never really set the ground rules. Basically, what the mediation protocol does, it sets the ground rules that everybody agrees to.
Thank you. You don't see any conflict between these protocols and most states or countries' ethical rules for mediators, right?
No, in fact, essentially, we were talking about 6 areas of discussion, and under those areas of discussion, you could have any number of different approaches. For example, under general process, if I edited a book years ago called Suha, and it's a Palestinian mediation process, and the mediator is expected to take a particular strong hand in the mediation, to work with the parties separately, to bring them together at the end. I mean, there are a series of things that happen. So if I'm talking about the general process and I explain that to the parties, they can say, "Well, I'm not comfortable with that. I don't want you to do shuttle diplomacy. I want to sit down in the room with them." Or they can say, "Well, okay, that's fine. I like that approach. You can do that." If it were a totally different approach, something completely different from that, and I talked to you about it and you said yes, you're not you're not restricting the mediator's performance. You're not restricting the mediator's style. You're simply saying that the parties should be given advance notice of what that style is and how they're going to operate with you. So I don't think it conflicts with any. As you know, I've written and talked about mediation ethics for a long time. I don't think it conflicts with any of the standards or ethics frameworks that are out there. In fact, I think it strengthens most of them.
Yeah, no, I tend to agree. Okay. When people go and endorse, I see that there's multiple organizers who have already supported you guys, whether it's mediate.com or ODR Latino America. So if an individual wants to endorse this, they just go to the website and give their information, then they'll be able to use a seal on the website.
Yep,
Is that basically it?
absolutely, absolutely. What we're not trying to create is a bureaucracy.
Hmm.
What we're trying to create um, is a place where practitioners can go to get ideas and guidance about how to deal with the opening of mediation for their parties. And then what you do with that, how you describe your process, how you describe the way you deal with confidentiality, all of that doesn't change anything about your practice as long as you're operating ethically. But what it does is basically say, I will in fact engage in a dialogue with my parties to make sure that they are engaged in true self-determination when they come to work with me.
Okay. And one more thing. When did the organizers get together to begin the process? This was pre-COVID, correct?
Um, well, the push for the Universal Disclosure Protocol for mediation didn't start until the Singapore Convention rollout in August of 2019.
Okay.
I have been, as I said, along with Leo Wing and some others, have been writing about mediation ethics for a long time. But when I had done some things with the UN UNCITRAL before, and when I saw the when I saw the Singapore Convention, I think it's a great idea, but it's a political document. I mean, it's everything that comes out of the UN is. It's a compromise. So, there are things that are there and things that are not there. And my reaction to the Singapore Convention was, this is a great idea. And the one place that I see that we might be able to add some value is in the notion of what standard behavior is. Not because we want to create standard behavior, but because we want to create understanding about behavior and understanding about self-determination. So that in the rollout in Singapore in 2019, Anna and I presented the idea of the disclosure protocol at the rollout when the convention was first presented to the public. And so we've been working on it since then. So we put together the international groups, we got the feedback, and put together the draft that's on the website. And all that's happened over the last couple of years.
Okay. And that's why I had asked, because do you think that ODR and the big push of it during the Zoom boom during COVID, does the protocols in any way, should they be changed or updated because of ODR?
No, I don't think so, because one of the areas that we talk about is technology. Basically, like everything else during COVID, international commercial mediation has become common on video and using other kind of technology tools. And so one of the things that everybody said you must include in a protocol for disclosure is not only what am I using, but why am I using it? How does it work? And I've talked in other places, for example, about the idea of a damage risk assessment. That's one of the things that I would talk about the parties with under the technology area in the protocol. Is okay. You have very sensitive information. We're going to use this particular piece of technology because it's more secure than the others that we could use, and it'll protect your information more. So that's, what we try to do is leave room for individual mediators and for countries and regions that have rules about mediation to be able to operate in a way that people understand. And that's the bottom line. We're trying to make sure that people understand what they're getting into when they get into international mediation. And to Natalia's point, it works for any kind of mediation.
And having said that, I think it will be time to wrap up. But what I would like to convince about our listeners and viewers is the most important part of it. Because my understanding is, and again, Dan, correct me if I'm wrong, this entire thing, this protocol was created to help both the mediators and the parties to create mutual understanding. So it's not like another sophisticated document that is there to make things more complicated and to therefore just frighten everybody and just be avoided. So, like creating another additional current that will be saying, I am not using Universal Disclosure Protocol for mediation, just the opposite. The thing that we are using as mediator, Universal Disclosure Protocol for mediation, is a sign that we are acting fairly, that our parties can be well informed about what's going on, and the checklist is already there for the mediator to go through with the parties. And therefore, if it's a commercial mediation, we ensure that this mediation that we are running and therefore the mediated settlement agreement we are entering into will not be set aside on the grounds that there was a severe breach of the mediation or mediators rule under Article 5 of the Singapore Convention. I hope I got it right, but please correct me if
Yes.
I'm wrong.
No, yes, you did. And as I said, we didn't create this to be part of the Singapore Convention, but I think the use of the protocol would strengthen one's position under the convention because it makes clear what the standards are that you're operating in. And that can only be a good thing.
Thank you so much, therefore, and we encourage everybody to endorse and then use the Universal Disclosure Protocol for mediation, whether commercial or with individuals or for whatever any other reason.
All right. Thank you so much, everybody. I'll definitely put the link to this on the bottom of the YouTube video so folks can check it out. But also, Instant Mediations will have a blog post about it. All right. That's it for now. Signing off.